There we
Well,
go.
thank you, Stephen, and I appreciate the introduction. Just to kind of add on to that, so I've been practicing exclusively in the area of employment law since 2015, and I act for employers and employees, but mainly employees. The one thing you should know about me for today's purposes is that I practice nearly exclusively in the non-unionized sector. Now, the unionized sector is typically not referred to as employment law, but labor law, which comes with a whole host of considerations regarding collective bargaining agreements, rights, certifications, and other matters, none of which I have a particularly great amount of expertise in. So I won't get into any of that today. What you should know, if you're or anyone you know is in a unionized position, is that a lawyer cannot act for a unionized employee. So while these things I will talk about are still useful for anyone who's a unionized employee, the only place you can go to for actual representation and legal advice in those instances are your union representative. So with that being said, what is employment law? Well, the best place to start is to look up what makes up this concept that we call employment law. And the first place is written statutes, the written laws that are passed by Queen's Park or Parliament. And I've given a few examples on this slide. For example, we have the Accessibility for Ontarians with Disabilities Act, which requires employees to be trained on assisting individuals with disabilities in the workplace. There's the Occupational Health and Safety Act, which allows people to refuse unsafe work. The key ones, though, that we're going to talk about today are the Employment Standard Statutes and the Human Rights Code. And what are the main purposes of these statutes? Well, that is to protect employees. What is really most of employment law in the province of Ontario is about is protecting employees, recognizing that there is a power imbalance, natural power imbalance between employees and employers, and ensuring that employees have a minimum level of standard of their rights. And this is the case whether it's wages or vacation, accommodation, or their rights on termination. Now, an extremely important source of employment law is the common law. The common law is the law that's developed over the years by judges who rely on prior precedent. And this is where the vulnerabilities, the power imbalance, and the importance of employment in a person's life really come into play. That matters really the most when we're talking about severance pay entitlements. Because what the common law tells us is that the minimum entitlements in the Canada Labour Code and the Employment Standards Act are just that, minimum entitlements. Those individuals have entitlements over and above their those minimum entitlements to their full severance under the common law, by and large, right? And those severance entitlements are not based on a week or any particular amount per year of service. They're based on no mathematical formula, but rather based on the circumstances they are in and how long that employer should expect that person who's just lost their job to find a new job in light of their age, their position, their length of service, their compensation, and important for our conversation today, their medical condition, if that employee has one. So while someone's minimum entitlement might only be 2 weeks pay, that same person may also have a full entitlement that is as much as 3 months, 4 months, or even 6 months pay. So it's quite a big difference, and that depends on whether that person has signed a contract, because almost everyone gets these entitlements unless you have signed a contract limiting you to only the minimum entitlements. Now, if that happens, if you've signed such a contract, then upon termination, you may only be entitled to those minimum amounts under statute. It's a very small fraction. And that is why all employees have to be very careful about signing an employment agreement, especially if they're being asked to sign one while they're already employed, even if it is for promotion. And that being said, the common law tells us that it's not enough for there just to be an employment agreement. There has to be termination language that complies with the law. And in my experience, most of that termination language actually doesn't. So for most people who've signed those employment agreements, most of those termination clauses are completely unenforceable, particularly those that were not prepared in the last few years. So where there are clauses that in an employment agreement that are not enforceable, we wipe it away, and that person is entitled to the same severance that everyone else gets, their full entitlements based on their age, their position, and length of service. Now, I could honestly do an entire seminar on termination entitlements, including employers who allege just cause, employers who misclassify employees as independent contractors, and various issues that come into play in terms of the size of severance packages, such as bonuses. We won't have time for that today. So I'm just going to leave you with this. when it comes to all of these issues, the main theme is that employment law is there to protect employees and always errs on the side of protecting employees. So what do you do when you come back to work and you need accommodation? This is another issue that is going to be very relevant to us today. Well, the first thing that you do is you go to your doctor and you go by your doctor's recommendation. But just because your doctor recommends something does not mean that your employer necessarily has the right to provide that exactly as the employer has recommended. So when we call the right to accommodation, which is going to be a major topic for today, it's the right to reasonable accommodation, but not perfect accommodation. So the employer should not have to they can't unnecessarily say, well, we just don't feel like it. It's not convenient for us, or we don't want to spend any money on this. But it has to be possible for the employer to run smooth operations. And we can't ask the employer to make an investment that is so burdensome it would threaten those operations. So for example, your employer may have to offer you breaks during the day. They may have to allow you to take time off to visit a doctor. They may not necessarily have to allow you to work from home full-time or at another location that is closer to a supportive family member or your medical specialist. That might be the ideal form of accommodation, but if it's not practical and there are other alternatives, your employer doesn't necessarily need to provide it. So I'd like to jump right into that in a little bit more detail, because accommodation is obviously going to be very important for people watching this today. And we have two human rights statutes that come into play for someone working in Ontario. The first is the Ontario Human Rights Code, and the second is the Canadian Human Rights Act. Most people are going to be covered by the Ontario Human Rights Code, because the federal act really only covers select groups of industries, most significantly banking, telecommunications, rail, air, or interprovincial transportation. But in both cases, we have disability as a protected ground of discrimination. So no matter whether you're a federally covered or provincially covered, you're always going to have a right against discrimination on the basis of disability. Now, they do define them a little bit differently, and I'm going to go through both of those, but that difference doesn't matter all that much. I just do it for context and to show how broad they are, right? So I won't go into this definition we have in screen in detail. I'm not going to read through all of these various examples they give of disability, but you can see it's not only for physical disabilities, but for mental impairments and disorders as well. So someone who may not be suffering at the time from a physical disability, but might be suffering from the fallout of that on a psychological basis is going to be covered as well. Now we have the federal version, which is much simpler, but you can see again, it includes not only physical, but mental disabilities. And in both the federal and the provincial statutes, individuals are protected from any sort of discrimination on the basis of their disability. So that means if the person is terminated, if the person is demoted, or they're not hired because of a disability, that could be a human rights violation. So by way of illustration, so if someone is demoted after coming back from a disability leave, or someone is not provided accommodation in the workplace and their employment ends because they cannot do their job without that accommodation, that would very likely be a human rights violation. Now, the exception to this is if the employer can show what's called undue hardship, which means, as I was mentioning before, it's practically impossible for them to do it. It's just not feasible at all for the company to do it without jeopardizing their operations, or if they can show that the aspect of your job that they cannot accommodate is what we call a bona fide occupational requirement. So someone has a job that requires standing, cannot be done without standing, and you have a disability that doesn't allow you to stand. It's a bona fide occupational requirement. There's no way to do the job otherwise. The employer doesn't have to accommodate. They might have to try and find an alternate position for you, but they don't have to change the fundamental job necessarily to accommodate you. Now, if an employer can't show that, and someone is found to have been discriminated against, they can be entitled to damages for both what we call loss of dignity as well as loss of wages, particularly if that discrimination is concerning a refusal to hire or a termination. So I thought for today's purposes, I would get a few cases involving Parkinson's disease that I thought would naturally be of interest today. And I'll just go through a couple of them that I found. And I actually believe these are the only at least the only prominent ones on record that I found that really directly involved Parkinson's disease. So the first one's from 6 years ago. Involves a complainant whose last name was Risman, and the employer who was on the other side of this was LA Fitness. This was a case where a part-time cleaner lost his job after working for an employer for only 3 days. Okay, he worked 3 shifts, and after his 3rd day of work, he was told that he was let go, and someone else was being transferred to his position instead. The tribunal found that he was entitled to $25,000 for compensation to injury to dignity and feelings and self-respect, and also gave him $5,000 additional for wage loss. And this is an interesting example because, leaving aside the human rights issues, someone who was let go after 3 days would never be entitled to anything like this amount for severance. But because of the severity of the discrimination, and because this was a discrimination case, the award on the basis of injury to feelings and self-respect was alone fairly significant. I contrast that with another decision, this one out of British Columbia from 2008, where, among other things, there was a dispute about whether the employee had quit or was terminated. But it was interesting here because the employer relied on the fact that the employer, that being K-Line Trailers, knew that the employee had Parkinson's disease, and there had been some discussions about it. But the tribunal ultimately found that there was no decision made to disadvantage the employee as a result of that disease. So really, in order for there to be damages awarded, there has to be that link. It can't just be you have Parkinson's and your employment has been terminated, or even you've discussed your Parkinson's disease and then your employment is terminated. In the Risman case, what made that so high is that the employer found out that the employee had Parkinson's. They had a discussion about it. Right away, they said, we're going to put someone else in your role, and you're gone. So obviously, there was some link there, and that's why there was discrimination damages awarded. So coming back to what I was mentioning earlier, what do you do if you need a medical leave? So the first thing is you get a doctor's note, because again, you rely on your doctor's recommendation. A question often arises here, how much detail needs to be included in that doctor's note? And the rule here is that the employer is entitled to the prognosis, but not the diagnosis. So the employer is entitled to know how long you're likely to be away, what accommodations you're going to need when you come back, but it really is kind of a need-to-know basis situation. The employer is not entitled right at the outset to your full medical file. They're not entitled to know all the various symptoms you have, how long you've had this disease. The employer may ask you to fill out something called a functional abilities form or a cognitive evaluation form, and those are fair game because those are focused on what are your abilities, what are your restrictions, and what is your prognosis. But only in very rare cases can an employer actually order an independent medical examination and get into detail about your condition. Generally, you're allowed to rely on the expertise of your own medical specialist. You just have to get that in writing, get it to your employer, and I always recommend to email that so that there is no question that the employer received a copy of that. So the next question is, how often do you have to do that, right? Because you might be on a very extended medical leave, you might be on long-term disability, and how long do you have to keep sending medical notes to your employer saying, I'm still away, I need to be, I still need to be away, I still need to have these accommodations when I come back. And technically, the rule is as often as they ask, right? So if they don't ask you for 3 months, then you're technically under no obligation to do that. That being said, I usually say every 3 to 6 weeks is a pretty good rule of thumb. If you're updating your employer every 1 or 2 months, it's going to be very difficult for an employer to argue later that you weren't keeping them in the loop. And you typically want those updates to revolve around your doctor's appointment, so you can provide an updated note, not just saying, you're still out of work, but saying this is when your next appointment is, this is when you will be reassessed, and as of today, you're still totally unable to do your duties. Or if you need accommodation and you're getting a note for accommodation, you still need these accommodations. So let's say you go on medical leave, you come back, and your employment is now terminated. or you've had a series of periodic medical leaves and your employment is terminated. Then what? Well, obviously we're gonna look at was this termination discriminatory, and if there is that direct link between what we call a nexus, right, between the um, disability you have and the decision to terminate, if any part of that was tainted by them disadvantaging you as a result of your disability that they knew about, then we have to look at discrimination. But often the bigger entitlement is severance, particularly if you've been an employer for a long time. Now, it's very possible that they terminated your employment after coming back from medical leave, and it still may not be discriminatory, right? The termination may have absolutely nothing to do with the disability. For example, if there's a restructuring and your entire department is wiped away, there may be no basis for you to argue that, but we're still looking at the adequacy of the severance package. So typically the big question here is, how long is that employee going to be out of work? How long are you going to be out of work now that you've lost your job? And really the key question is, how long should your employer expect, given everything that they know, that you should be out of a job? And the longer that employer should reasonably expect that you will be out of a job, the greater your entitlement to severance is going to be, because the purpose of severance is not to reward you for past service or to acknowledge that you were a good performer. It's to acknowledge the fact that you've now lost your job, you're going to be out of work for a period of time, and Canadian law recognizes that you should be compensated during that time. You should have a bridge to your next position. You shouldn't be out of work and out of money at the same time if it can be avoided. And when we're looking at what should those employers' expectations be, we look at all the things the employer knew at the time, including if you were coming from a medical leave or just come off a medical leave. Obviously, it's going to take you longer to find work because you might need accommodations, or you might not even be in a position to look for work because you are in the midst of a medical leave. That is going to extend your severance package. Now, the other thing we have to think about, though, is that anyone who challenges their severance package has what is called a duty to mitigate. Now, this is something that employers will always argue, basically, that an employee cannot simply sit on their hands after they're let go and just wait for the severance to come in. Right? Severance is meant to compensate you until you find your next job, your next comparable job. But if the employee fails to make any efforts to find a new job, they're going to be entitled to less severance. Now, on the other hand, if that person cannot look for a new job because they are totally disabled, for example, they have a doctor's note that shows that, they would be exempt from that duty to mitigate because you're not obligated to go against your doctor's advice to mitigate. If you are completely disabled, completely unable to turn your mind to it, then you are free and clear of that. Now, the other important piece here is that I've seen not a lot, I'll say, but a couple of employers argue, well, I terminated your employment during a medical leave. You can't work right now anyway. Therefore, what am I paying you for severance? I haven't put you in any worse position. Now, that's not the law. The law is clear that even if you're not earning anything at the time that your employment is the time that you lose your employment, you are still entitled to severance based on your full rate of pay. So just because you're on a medical leave and not earning any income doesn't say that, okay, I'll pay you your severance at $0 an hour or $0 a month because that's what I'm paying you. No, it's based on what you would have earned at the point you would have come back to work. Now, if you're on a long-term accommodation that reduces your pay because, let's say, the employer has converted you to a part-time employee, then in that case, the severance would be based on the part-time earnings. But they can't take advantage of the fact that you're on a leave because, of course, that creates a perverse incentive for employers to terminate people while they're on a medical leave of absence. And the law does not allow for that. So what I've just talked about is what a wrongful dismissal. Okay, a wrongful dismissal is the term that we use not when an employer was wrong to fire you or was not able to fire you, but when they didn't pay you an adequate severance package, right? They didn't give you adequate working notice, which counts towards severance, or they didn't give you adequate compensation in lieu of working notice to give you an opportunity to find a new job. That's a wrongful dismissal. Now, where does a constructive dismissal come in? A constructive dismissal is where the employer has taken actions without the employee's consent that are so severe, so fundamental, so contrary to what we call the implied terms of the employment relationship, that the employee can act as if they were fired and pursue their severance. And the law will construct a dismissal even though the employer has not admitted one. And in that case, if you can establish that you have been constructively dismissed, then you're entitled to the same severance that you'd otherwise be entitled to, right? So ideally, if you want a severance package, the better situation to be in is a wrongful dismissal. You don't want to be in a constructive dismissal because constructive dismissal means you have to prove that you've actually been terminated. Your employer won't admit that. If your employer is terminated and you're just talking about severance, you can skip all of these steps. You can skip this burden. But sometimes the employer won't admit it. So the first and simplest example in the disability context of a constructive dismissal is where an employer fails to accommodate, right? The employee goes on a medical leave. The employer simply refuses to bring the employee back. Or the employer refuses to bring the employee back on a graduated return without good reason, refuses to allow that employee to take breaks, or anything that makes that employee's job not just inconvenient, but practically speaking, impossible given their medical restrictions. That can be a constructive dismissal. But what I have found over the last 9 or 10 years is the tricky thing about these kinds of claims, and why I pursue them very rarely, is that it's typically not as simple as an employer saying, we don't want you to come back. That usually doesn't happen. Usually it's an employer who claims, well, we want you to come back, but we can't provide these accommodations that you're seeking because it's just not practical for the job. Or that employee is requesting some kind of part-time work and the employer claims it's not available. And the problem that arises here when you're on the employee side of the table is that there's a real imbalance of information because we don't know what opportunities are actually available. We don't necessarily know what the operational requirements of the employee are, and we may not know that until we actually start a claim. So it's pretty risky to start, and it should only be reserved for really as a last resort, extreme situations, or when we have really concrete evidence that the employer is not being forthright about their actual restrictions. Now, an even riskier form of constructive dismissal, which in my view should really be reserved for only the very most extreme situations, is the poisoned work environment, right? Or sometimes people think of that as the harassment to constructive dismissal. This is where the environment has become so uncomfortable that even though the employer is maybe on paper accommodating the employee, or there's no accommodation necessary, and otherwise complying with their obligations, the employee has to leave their employment. So, for example, an employee comes back from a leave, discloses their disability, doesn't need any accommodation, but they're called names, there's derogatory comments made about them, or maybe the workplace is poisoned in a more indirect way by excluding that employee from meetings, or perhaps changing the employee's duties to diminish their role in the organization. And these are typically very, very hard to prove. And what I always tell clients considering such a constructive dismissal is that there is a very significant chance that the court may not agree with you, in which case you resigned, you have no entitlement to severance, and you may not even qualify for employment insurance. So these are by far the most difficult, the most risky constructive dismissal cases, and I typically only recommend them where the employee's health is literally at risk by continuing to work for that employer. So these are not constructive dismissals that should be sought out. They shouldn't be pursued lightly, even if you feel you're being harassed at work. What I usually try to do, instead of claiming constructive dismissal, let's see if we can resolve the situation. Let's put the employer on notice that you are being harassed, that you are experiencing this poison work environment, and hopefully we can take steps to maybe separate you from the employees who are responsible for that, or change the reporting relationship. So this is basically the final topic I want to cover today, and then I'll open it up to questions. This is a really, really important subject, and happens often with people with long-term illnesses that come up in the context of employment. And this is called frustration of employment, where someone becomes ill for such a period of time, such a long period of time, and they need to be off for such a long period of time that, practically speaking, it's impossible for that person to return to work in the foreseeable future. And perhaps the doctor will validate that. Now, in that case, it's no one's fault that the employment has ended, right? It simply ends by virtue of the circumstances. And in this case, the employee is not owed their full common law severance because the employer hasn't terminated your employment. It's just ended, right? It's almost like act of God, right? The employer is not going to have to pay you under the common law the way they would have to pay you if they terminated your employment outright or if your employment was constructively dismissed. There are, however, nonetheless minimum entitlements that are owed in this situation. Okay, so for someone who's been employed a long time and earned a high rate of compensation, or one or the other, the minimum entitlement alone can be significant. So that may very well be worth pursuing. So you may say, look, I'm not going to come back. My employer's not going to terminate my employment. So I'm basically going to have to acknowledge that this isn't happening. My employment is not going to continue. So in that case, it might be worth pursuing your minimum entitlement as frustration of employment. But what happens if the employer doesn't want to acknowledge it, right? There are some instances where the employer will actually write to you and say, your employment has been frustrated. Here are your minimum entitlements. And if it's truly been frustrated, well, then that pretty much resolves the issue. But sometimes an employer doesn't want to acknowledge it. The employer may figure, well, this employee is on leave. I don't have to pay them. Perhaps your employer is not continuing your benefits. So what's my motivation to say that the employment is frustrated? And we know the answer to that from a case that I litigated about 6 years ago called Hoekstra, where my client successfully triggered his minimum severance entitlements, despite the employer arguing that the employment had not been frustrated. We had a doctor's note from Mr. Hoekstra's physician that said, he's not likely to return to work at any point in the foreseeable future. And so for that reason, the court found, well, just because the employer doesn't acknowledge it doesn't mean that it's not frustrated. Now, in Mr. Hoekstra's case, it made sense to trigger his termination entitlements because the employer had cut him off his health and dental benefits. So Mr. Hoekstra figured, well, what motivation do I have? I have no more link to this employer. I'm not getting anything out of them. I know I'm not going to be able to return there. And so I want my severance entitlements. And we were able to get those for him. And that was a significant amount. It was something, it's a public decision, so you can look it up, but I think it was something like $30-something thousand. Now, that made sense for him. But for many people, it may not make sense to trigger your frustration because you may be receiving benefits. And if you trigger frustration of employment, those health and dental benefits are going to end. It also may not make sense if you're receiving long-term disability benefits, because for some people, for a lot of people, their disability plan has a set off where if you receive any severance, it's just going to be set off against your disability benefits and you'll be no further off than where you started. So in those cases, again, you're not getting anything. You may not come back, but it might just be best to just ride out your benefits and hopefully not draw attention to your employer. So it really is a case-by-case situation where we have to decide whether it's actually a benefit to you to declare or to pursue frustration of employment. And as a final point today, I'll just point out that, if you are out for an extended period of time, you want to make sure that you are taking advantage of any long-term disability benefits that you have, because usually disability benefits are worth much more than a severance entitlement is going to be. A severance entitlement might be 6 months, 8 months for a very long service person, even 2 years. An LTD benefit is usually going to be up to age 65. And if you are denied disability benefits, you want to make sure that you pursue those and that you coordinate those with the severance entitlements. You typically want to get that finalized before you deal with any severance entitlements. So you'll want to coordinate that disability denial with a disability lawyer and an employment lawyer. That's it. So any questions, I'm happy to answer. And about any of these topics, I think we still have about 15 minutes.
So thank you very much, Jon. That was a avalanche of information.
Hopefully not too much.
No, it really shows that you were really prepped for this presentation. We at PSSO really appreciate that the work that you put into this and the knowledge that our our clients will be able to benefit from this, not just now, but in perpetuity when we have this uploaded. So I am going to stop the recording just so that people can ask their questions. We have we have one question in the chat, but I will stop the recording. So now once the recording stops, you can feel free to ask John your questions. So that's stopping now.